各位贵宾，会议现在开始。同时提醒您，如稍后要进行发言的话呢，可以稍微放慢您的速度，以利口语老師進行完整翻譯。謝謝。The meeting will now continue. Mr. Dory, the floor is yours.
The last cluster of the Convention on the Rights of the Child is on child protective measures. And I will start with the questions on this topic. First, the minimum age of criminal responsibility. It's not completely clear to me what is the age. I found 14. I found a category of children between 7 and 12. And I was wondering what happened with the children of 12 and 13 if the minimum age is 14. And what happens if those children commit a crime. So first about the category of 7 to 12. It's a little bit peculiar that those children, there is in the statistic a category of child criminal offenders, and that apparently applies to children between 7 and 12 who commit a crime or another offense. But at the same time, there is enough information to tell you that those children are not dealt with through the criminal justice system or the juvenile justice system. They are dealt with in other ways, although it's not clear what kind of ways are exactly applied to children who are 9 or 10 years old and are stealing something from a shop or from another place. So it's the question, why do you, in your statistics, have a category, child criminal offenders, that deals with children between 7 and 12 who are never prosecuted? At the same time, I'll give you an example of 2015, 686 children committed, are belonging to the category child criminal offenders. It tells in the statistics that 410 are not forwarded to the courts, 220 are in process of court trial, and I need an explanation what that means. If you are between 7 and 12 and you are in a process of court trial. And I still repeat the question on the age category 12 or 13. The status offenses is another issue that needs some attention in my view. The number of status offenses, according to the statistics, is quite impressive. 3,800 in 2014 and over 4,000 in 2015. Status offenses are not explicitly defined in the report, but there is an indication that it has to do with unruly behavior, running away, or other problematic behavior. Again, there is in the statistics a category that tells you they are not going to court. The question is, who is deciding that a child who apparently is registered as a status offense, why that is not why that child is not going to court. And the question is who decides. Because in the process of trial, according to the statistics, the great majority of those status offenses are in the process of trial. So there is, in that regard, the question, what happens with the qualification in process of trial? Are they tried in court or are they not? What happens? What we know from the measures taken regarding those status offenders, there is a category protective measures, there is a category protective disciplining. Close to 1,000 of those status offenders are subject to protective disciplining. I like to know what exactly is meant by protective disciplining. Another category of those status offenses are in reformatory education. Does that mean they are placed in reformatory schools? That's another question. So, in terms of the responses, I have a question on the status offenses. There is information that the judge may decide to proceed the case to court. Then they will further decide whether to render protective measures or of which the purpose is consultation and protection, that is sending them to proper institutions or whatever. There is apparently a deprivation of liberty possible, but the key issue is here the judge decides to proceed the case to court. That carries a flavor of lack of impartiality because it most likely is the same judge who is going to make a decision. And he first decided that the case is going to court. So that's another point that I need clarification for. The next issue is the police investigation and interrogation. The whole juvenile justice system is in most countries composed of 3 moments in the process. First the police, then the prosecutor, then the court. It is important to note that for children, the first experience with the juvenile justice system is the police and the police interrogation. When the child is arrested for any kind of suspicion of having committed a crime, he is taken to the police station. Take as an example, he has broken into a school, took some laptops, and now he is in the police station and he is interrogated by the police officer. The first question is a lawyer present at that interrogation by the police? Same question. Also, or at least one of the parents, are they present? And when it comes to the lawyer, the question is, that child, how does he or she get a lawyer? Is that assigned to her or him at the moment that he or she is in the police station for interrogation? The other issue, I'll come back to the interrogation in the context of sexual exploitation. The pretrial detention is my next issue. There are in the report explanation of, let's say, criteria for using pretrial detention. So that is clear. Now, the duration, that's a question. There is one information that tells me it's maximum 2 months. there is a decision possible by the juvenile court. Whether that is at the request of the prosecutor, I assume it is, to extend the pretrial detention. The question is, what happens if the police investigation takes more than 2 months? Does that mean that a child is released after 2 months? Or is there another way to continue with that deprivation of liberty? And I assume those juveniles are all in detention houses. The next issue is on, well, what a pretrial detention concerns, there is another question that's about, if it lasts for 2 months, is there a regular review by the judge of the necessity of that continuation of the pretrial detention? And is that automatically, or is there a lawyer who can approach the court and tell or ask for a review of the placement in pretrial detention? Diversion. The question is diversion. It's not very clear. The term diversion is not used in the statistics, nor in the text of the reports, 1 or 2 times perhaps, but there is no clarification of what diversion is. When diversion becomes a possibility, is that already at the police level, at the prosecutor's level, or at the court level? I'm reluctant with the court level because you know that the definition of, the term the diversion doesn't appear in the convention, but there is an understanding that it has to do with Article 40 of the convention, and in particular paragraph 3, and there it says that the states parties, whenever appropriate and desirable, measures for dealing with such children without resorting to judicial proceedings, providing that human rights and freedoms are guaranteed, which suggests the diversion takes place before the trial in court. But it's not clear to me when exactly diversion is possible and what kind of measures are then, in addition to warning and similar measures that are presented in the statistic, but what more is possible? And is there any particular service that organizes diversion measures, or is it a matter of the police or the prosecutor? So about implementation of diversionary measures. The sentencing. The one thing that is not clear to me, it's clear that you can be placed in a correctional school or in a reformative school or a reform school. There is a detention house that is used for pretrial detention. But in the list of possible sentencing, I never found in the documents the sentence of the judge to send the boy or girl to a prison, to a detention center. Is that not an issue? Or if it is possible to send a juvenile, age 16, 17, to a detention center, the detention house, then the question is for how long, what's the maximum? Because for placement in reformatory or correctional schools, I need some further clarification. It's 2 years max, it's extendable for another 2 years. The overall maximum is 3 years, and it will end at least at 21, the age of 21. So the question is it 2 years as a max, or is it the first decision of the court to send a boy to the correctional or reformative school, and then there is a possibility to extend it? So Back to the legal aid. As I said, the first question is, does the child have legal aid in the first moment of the entering in the legal system? But there is information about a legal aid foundation, not clear to me whether that's public or private, and it informs us in paragraph 298 of the report that that foundation received in the years 2011-2016 7,600 plus applications by representatives, and now the surprising part, by representatives of children below the age of 12. 76% of those applications were granted. I didn't find information about legal aid for 12 to 18, and the surprising part is that it is talking about children between 7 and below 12 who will not be prosecuted in court. So why do they need legal aid? And why do parents apply for legal aid? Not clear to me. So far, the juvenile justice questions. Drug abuse. There are two centers, and I need some clarification about that. They may be the same, or they may be different. There is a narcotic hazard control center, and there are drug abuse prevention centers. And they can be established by the local government. And the question is, what's the difference between the two and the role? The sexual exploitation of children. There is in 2015 a commendable new piece of legislation, the Child and Youth Sexual Exploitation Prevention Act. And there is in the information a list of sexual crimes, and they are focusing a lot on intercourse, and there is very little or nothing about sexual abuse or sexual exploitation through internet. And the optional protocol on sale of children, child pornography, child prostitution, child pornography, is dealing in the sector of child pornography with virtual forms of child sexual abuse or exploitation. So the question is, where are we with harmonizing the national law of Taiwan with international standards and rules when it comes to the protection of children, victims of sexual exploitation or abuse? There was no information about extraterritorial jurisdiction. I'd like to know whether it's possible for the law enforcement in Taiwan to prosecute a man from Taiwan who committed a crime in Vietnam or in Cambodia of sexual exploitation, and whether for that extraterritorial jurisdiction it is necessary that the crime you want to prosecute the man for is a crime also in Vietnam as it is in Cambodia, the double criminality standard. That's about the enforcement, the law enforcement related to sexual exploitation of children. The protection of the child victim. What it said in the report is that the child can be placed in an emergency case for 72 hours, and that if we need to continue that, there is a court decision necessary to extend the 72 hours. That's about it. The protection of the child victim is, of course, very important, and measures to ensure that the child is free from further sexual exploitation or abuse is critical. measures in that regard are necessary, but one of the elements of being a victim of sexual exploitation, sexual abuse, is that you may end up in court as a witness, and you may be the only witness. So that creates all kinds of difficulties in trying to get sufficient evidence. But to be, as a child, subject to, and perhaps also an object of the criminal justice system, and I'm talking about the criminal justice where the perpetrator is the key person. He is accused of and is prosecuted for sexual exploiting, sexual abusing a child. The child, most likely, has to be interviewed even before the court trial takes place. And the question that I like to have answers to, what are the rules and what is the practice if a child, a victim of a sexual exploitation or sexual abuse crime, is interviewed, a starter most likely by the police? Are there special rooms for those interviews? Are there well-trained police officers to do it? Are those interviews recorded, at least in order to avoid a continuous repetition of those interviews by other law enforcement officials, after the police, the prosecutor, and other, the psychologists, the psychiatrists, whoever is trying to get information from the child? Is the child provided during the process with assistance, legal assistance and other assistance, so that she or he is aware of what is happening and will be informed about the various steps in the process? And when it comes to interviewing children, and particularly when it comes to the court trial, in countries where cross-examination is part of the criminal law system, and particularly the part that takes place in court, question is, are there rules, are there practices to prevent the child from facing and being confronted with the perpetrator? Screens in the courtroom, the child in a separate room, assisted by her or his lawyer. What are the practices in Taiwan when you deal with that kind of cases? And are there possibilities to avoid for a child the cross-examination in court? Is there perhaps, let's say, an age limit below which children are not taken to court for being cross-examined? Or does it not matter what the age of the child is? So that's about sexual exploitation of children, in particular the role of the child as a witness in court. Finally, it has been raised by Mr. Cantwell in relation to the alternative care institution, but governments are investing a lot of money in rehabilitation of juveniles in conflict with the law, putting them in institutions for 2 or 3 or more years, and then are released. What happens with children? Is the release, which is usually predictable in terms of when it will happen, preparation for release, support after the release in terms of housing, employment, education? Is there a probation officer, a juvenile probation officer in Taiwan who can provide the necessary support and guidance for the child who is now out of the reformatory school or the detention house or a prison? Those were my questions. Other members of the committee? Go ahead. Mr. Cantwell.
I'd just like to add one question in relation to pre-trial detention. In many countries, the use of pre-trial detention is such that many of the young people detained before going to trial in fact do not end up with a sentence of detention. So that what we're doing is placing children in detention before saying they should not be in detention, or before the court decides that they should not be deprived of their liberty as a result of their offence. I'm not asking for statistics off the cuff at this point, but I wonder if you have any comments on the extent to which pre-trial detention is used in relation to the number of young people who are actually receive a sentence involving the deprivation of liberty subsequently. Thank you.
Yes, Ms. Scarp.
I would like to know if there is regular visits of judges or NGOs or other independent people in the reformative or correctional schools to view the situation of the children in these schools. And how can children in these schools complain against misconduct with regard to them? How can it be guaranteed to them that there will be an independent visitor who may carry their complaints? Is a separation between children and adults guaranteed all along the trial process, or the detention and trial process? I understand that there are some provisions that enable keeping children in pre-detention together for a certain time together with adults. So I would like to hear about it. If there is a special professional police interrogators for children, are they trained to know how to interrogate children with mental problems or children with disabilities? What kind of measures are taken to enable these children to give evidence in court? I ask not about victims of sexual assaults, but just regular witnesses at court. How are they helped to give their evidence? And is there a program of mediation between perpetrators and the victims to help a kind of diversion for the child who is in court or before being in court, meaning as a process of making him understand what he did, how to compensate the victim, and other measures that prevent from bringing him to the court. Thank you.
Your Excellency, those are the questions, so your turn to get answers to the questions.
Well, I think the Judicial Yuan, the Ministry of Justice, the Ministry of the Interior, the Ministry of Health and Welfare, and maybe NCC, National Communication Commission, can also provide information. The Ministry of Education, if you want to address what follow-up measures there are after the transition school, please feel free to jump in. Now, the Judicial Yuan, the floor is yours. I speak on behalf of the Judicial Yuan. I'm a judge. Thank you all for the questions. In response to your question, I would like to offer the following replies. First of all, 7 to 12-year-olds and also 13, 14-year-olds and children above the age of 14. What are their criminal responsibility under our law? According to the criminal code, those who are above the age of 14 will bear criminal responsibility. Only those who are above 14 will bear criminal responsibility. Those under 14 are not deemed to be capable of bearing criminal responsibility. No criminal punishment will be imposed upon those under the age of 14. In the Juvenile Delinquency Act, we do have this category, 7 to 12, 12 to 18, two groups. For 7 to 12-year-olds, they are defined as children. For 12 to 18-year-olds, they are defined as adolescents or teenagers. So for these two groups, as I said, 12-year-old, 13-year-old, they are defined as post-teens. They can receive protective measures. They are not criminal punishment at all. For 12 to 18-year-olds, they are not subjected to criminal punishment. But as I said, those who are older than 14, they can bear criminal responsibility. So for 14 to 18-year-olds, if they commit an offense for a minimum punishment of 5 years of imprisonment, then they will be subjected to criminal punishment because they are already over the age of 14. Another circumstance is the juvenile reaches the age of 20 after the action is pending. In other words, when he committed the crime, he was between 14 to 18-year-old. But by the time the case was reported and handled by the court, he was already 20-year-old. In this case, he again will be subjected to criminal punishment. So for 12, 13, and 14-year-olds, 12 and 13-year-olds, they will stay in the juvenile court and receive dispositions. As for 7 to 12-year-olds, again, from the criminal code's perspective, it is only when they violate criminal laws, even though they will not be subjected to criminal penalty, we have to look into the reasons why 7 to 12-year-olds violated criminal laws. That's why we provide protective measures and treatment. So next, I will talk about status offenses. According to Article 3 of the Juvenile Delinquency Act, even though the juvenile's action or behavior didn't violate the criminal law, but given his family background and some bad influences in his life. For example, he made some bad friends. These bad friends were former criminals, or his friends carried guns, weapons, or if the juvenile and his friends did drugs, none of this really constitutes criminal law violations, but their behaviors show that they are at high risk of committing crime in the future. That's why we would give them some protective measures and treatment. So this applies only to those who are aged between 12 and 18. For those aged between 7 to 12, children, we don't apply status offense procedures. You also asked about the ruling not to hear the case and ruling to initiate a trial. What do they mean? Ruling not to hear the case, I will explain what it means. There are two possibilities according to the law. Ruling not to hear the case can be interpreted as innocence and acquittal. In other words, after the investigation, the judge decided that the juvenile did not associate with bad friends or former criminals. The juvenile was not found to carry guns. In that case, the case will not be forwarded to the court. But if the juvenile is found to engage in problematic behaviors, but he has very good support network with teachers, parents giving him support, in that case, we will send the juvenile back to his guardians, parents or grandparents, and we will remind his guardians and parents to make sure that they must keep an eye on the juvenile, or we can send the child to counseling institutions, or we can have our juvenile investigator giving a warning to the juvenile. So these are the three possible dispositions if the child was engaged in minor offenses, which should not be forwarded to the court. But in the ruling to initiate a trial, again, the juvenile investigators will conduct an investigation to see how the juvenile's family background is like, whether or not he has parents to look after him, whether or not he is attending school, how well he behaves at the school, does he play truant at school, whether or not he makes any bad friends at school. And these will help us to decide what kind of protective measures the juvenile may need. And if there's a lawyer to help the juvenile, then the lawyer can also offer his opinions. And if the juvenile is working, the juvenile investigator will also go to his workplace to complete his investigation. After hearing the investigation results, the judge may decide still he needs to summon more witnesses to decide whether or not protective measures are in order for this juvenile. If it is decided that a trial should be initiated, then yes, it's the same judge who will initiate the trial. It's the same juvenile judge. Based on my own experience working at the juvenile court, because during the pretrial investigation, have gained tremendous knowledge about the case, the juvenile. So with this background knowledge, I can go on to initiate the trial. So after I make a ruling to initiate a trial, if a new judge takes over, in reality, he can only, in most cases, he can only make a ruling not to apply protective measures. But because I have been involved starting from the pre-trial investigation, I will most likely make a ruling for protective measures and treatment. Of course, the differences between the ruling not to hear the case versus the ruling to initiate a trial. If the ruling is not to hear the case, you already heard there are 3 options. If a trial has been initiated and a ruling for protective measures and treatment is made, well, actually, during the trial, if there's new evidence that persuades the judge that there's no need to apply protective measures, again, it's like the juvenile is innocent. In that case, if we believe that the juvenile has some behavior problems, then there are 4 options we can choose. The first one is we can give the child a warning and we can ask him to come on the weekends to receive counseling. The second option is to send the child, the teenager, to a probation officer, and the probation period cannot last longer than 3 years. During the 3-year period, the probation officer will stay in close touch with the juvenile, his teachers at schools, his parents, his employers, to make sure that during the probation period, the juvenile leads a normal, regular life. And at least, well, in some cases, over 6 months, after 6 months, the probation period comes to an end, or it can last as long as 3 years.
So the 3 treatment is different. That there is a fact of the criminal offense and the family is poorer on average, or the parents in this family also have criminal records and therefore may give bad influence to the child. Then I, in this case, will send the juvenile to a proper welfare or cultivation institution, or it may be a foster family or an institutions which help children without good family supports. But this kind of institute is not a prison-like institute. So this is the 3rd treatment. The 4th treatment is to send the child to a correctional institution. for 6 months to 3 years to receive reformatory education. This is the general procedure that is being implemented at the juvenile court and the different forms of treatment. Now, I would also like to add that if a child is above 14 years old and the offense is subject to a minimum of punishment of 5 years, then the juvenile court will transfer this case to the prosecutor. Well, in the Juvenile Delinquency Act, there's no involvement of prosecutors. There's no prosecutors at our courts. The exemption is that when we transfer such a case to the prosecutor, will there be involvement of prosecutors? And then the prosecutors may initiate a juvenile criminal procedure. And this procedure is very similar to the normal criminal procedure. If there's no probation given, then this child will be subject to imprisonment. If this punishment is for 5 years, then this child will be sent to a specialized correctional school. This correctional schools receive such children who are found to be guilty by the juvenile criminal procedure. It was also asked whether a lawyer will accompany the child during police investigation or whether either of the parents will be there. The answer is yes. Well, we will tell the child that he or she has right to counsel, but if he or she decides not to exercise the rights, or the parents decide not to exercise the rights, then there may not be a lawyer. But the parent or the guardian, such as an uncle or aunt, there will be an adult to accompany the child. After CRC is implemented in Taiwan, we require that if neither of the parents can come to the police station or there is no lawyer, then we require social workers to accompany the child during police investigation, while being in police station or in courts. I think it was asked about the procedure for a child is all conducted within the courts, the juvenile courts. But if the child is still a student, and sometimes if you go to the schools, it's going to maybe bring some problems for the child. But if not, we may conduct some questions and answering in the schools. As for pretrial detention, according to Juvenile Delinquency Act, the length is 2 months during investigation, but it may be extended for another month. During trial, it's another 2 months of detention, and the extension again is another 1 month. So in total, if this child needs to be protected and the judge is not able to finish collecting the evidence very soon, then it's possible that this child will stay in pre-trial detention for as many as 6 months. So I talk about the periods already, and do the judges review the necessity for such detention? Of course, yes. We will review whether the detention is needed. We will also review whether the request to extend the detention is needed or is necessary. During pretrial detention, the judge will work with juvenile investigator. When the child is in pretrial detention, we arrange juvenile investigators to go to detention center to visit the child to understand his or her situation, and if their behavior have changed or if the family has changed greatly, then the judge may consider to release the child from detention. It is possible that the parents or the lawyer take the initiative to apply to the judge that such detention is not needed, and the judge is convinced that the child will be released. As for diversion, currently in Taiwan, the judge makes such a decision when the case is discovered by the police. This case has to be sent to juvenile court. And the judge will decide whether or not to conduct a diversion of this case. I think in the reports, the Chinese mentioned will transfer. I think transfer is different from diversion. Transfer meaning that the child lives in northern Taiwan, say in Taipei, but for some reason this child goes to southern Taiwan and commits a crime. So he was sent to the court in Kaohsiung in southern Taiwan, but his residence is in Taipei. His parents or her parents are in Taipei, and the people he knows is in Taipei. So then the judge in the southern courts will transfer the case back to the courts in Taipei for the judge in Taipei to deal with the case, so that the parents of the child can come to the court and accompany the child more easily. So I think the Chinese wording here is transferring instead of diversion. Is it possible for a 16 or 17 years old of child to be sent to detention center? Well, if the elements are met, right, it's possible. In case when there's no one that can take care of this child, or when an order of custody is not proper, we will decide to send the child to detention center. If the child between 7 to 18 commits a crime, they may subject to detention center. So if it's a 16 or 17-year-old who commits crime, they might be sent to detention center. And the longest duration of pretrial detention is 6 months, as I explained earlier. As for legal aid, in principle, the child can't retain an attorney on his or her own expense. The child has a right to counsel. And yet, if this family belongs to low or mid-income family and they apply for subsidies, then we will arrange legal representation. In this regard, age is not a factor. As long as the previous elements are met, we made and help locate legal representation for the child. If this child has mental health issues or is delayed in development, we will also arrange a lawyer for this child. So this is my response to legal aid.那么，不好意思，我想要在您完全答复之前，我想要很快的再追问一个问题。我想要再很快的追问一个问题，就是14岁的儿少，如果他犯的罪呢？这个本刑是5年以上还是5年以下？因为我刚刚好像翻译没有听清楚，是5年以上还是5年以下？哦，5年以上是不是？好，那这个14岁的儿少有可能会被判自由刑、被监禁。对，好，那问题就是，如果真的是这样子的状况的话，他是要去成人的监狱吗？还是他会被送去哪里？我想要再厘清一下。
如果他不会被送到成人。
This child will not be imprisoned in an adult prison. as long as at the offense, this child was under 18 years old, then he or she will not be sent to adult prisons unless he's over 20 years old when he's sent to the prison. And so he or she will be sent to correctional schools as long as they have not reached beyond 21 years old. So we do not imprison this kind of child with adults together. And about whether there is follow-up counseling after the child is released from correctional school. Again, according to our law, according to Children and Youth Welfare Act, when children leave correctional schools, social workers will follow up with them. So, and do judges or other people make regular visit to reformatory schools or correctional schools? Yes. For me, I visit such places every 2 to 3 months. It is regulated in our law. Correctional schools or reformatory schools will receive such visitations from the judges. If the judges are in the same the judges have to visit such places every 3 months. When judges go there, judges will review whether these institutions have proper complaints mechanisms. So detention centers, reformatory schools, and correctional schools, according to law, have to set up a complaints mechanism. They must not hide the complaint from the regulators. So since there is a complaint and office in these places, we will go to these offices to see if there are complaints. I will also talk to the children in the institution and ask them whether they have made some complaints or whether there's anything they want to complain. And the complaint will be received and addressed. During pretrial detention, are children detained together with adults? According to our regulation, no. But in fact, there are very few cases of pretrial detention of children. So it's possible that children are detained with the adults in the same area, but they will be separated. They will be in different cells. They may be in the same buildings, but they will be detained separately. So there's a rule of separation. And when judges go to this kind of institutions, we are very strict in reviewing these practice. If this institution does not follow the rule of separation, we will correct the institution. And based on my experience, I think most of the time, most of the institutions are able to follow the rule of separation. Regarding children with mental health issues, if they have to serve as witness in courts, we will ask experts to accompany them, or we ask a parent to be there with them. And if the child is not able to express him or herself properly, we'll ask an expert to accompany them, and also maybe to help the judges to ask questions of the child. Lastly, I think the last question is related to restorative justice, whether restorative justice is implemented in Taiwan. Well, in juvenile delinquent cases, there isn't an official restorative justice mechanism, which is to say that there isn't such a setting before the trial for the perpetrators and the victims to talk what harm has been done, what compensation has to be made. So far, there isn't an official mechanism of restorative justice in juvenile delinquent case. But when it comes to compensation, victims and perpetrators may discuss the compensation in an outside court committee and to mediate such matters. Thank you. Okay, I think there is an extra information too. Hi, I am from the Judicial Yuan. I want to add more information to legal aid. First of all, the legal aid data we provide is only about children because the question was only about children. So the data we provide is data for children under 12 years old. If you need data for children between 12 to 18, we will be able to collect the data and submit it to you later. The current data includes data from civil cases, criminal cases, family affair cases, which apply for legal aid. So you mentioned that, well, 12-year-old children under 12 are not subject to criminal sentences. How come they need legal aid? This is because our data includes civil cases, criminal cases, and family affair cases. And can children ask for legal aid when they're investigated by the police officers at police stations? If their offense has a minimum punishment of 3 years, like robbery or forced sexual abuse, then children have the right to legal representation during police investigation. If the child is indigenous, and actually the Council of Indigenous Peoples asked the Legal Aid Foundation to provide special help to indigenous child. So there's no qualification required. As long as an indigenous child is in need of legal aid, such legal aid will be provided to Legal Aid Foundation. So our data does not include legal aid provided to indigenous child.
Action for the translation in response to 27. The legal aid here is really a pecuniary aid. It means it's a government compensation. It's another traditional meaning of legal aid here. Thanks.
Anyone who would like to add more information?
I didn't answer the question about cross-examination. So when a juvenile appears in the court, if it's about sexual exploitation cases or sexual abuse cases, according to our law, yes, the interview and interrogation will be video and audio recorded so as to avoid repeated interrogations. Also, when the child or juvenile appears in the court, according to the Criminal Procedure Code, yes, the cross-examination is part of the proceedings, but we don't want to put the victim confronting his perpetrator. Therefore, we can put the child victim in a separate room accompanied by a social worker. The cross-examination can take place as such in a remote way. Or we can ask the defendant ask questions first. We will ask the defendant, the perpetrator, through his lawyer or the judge. A list of questions will be made first, and then the lawyer or the judge will relay the questions to the victim. Any replies from the Judicial Yuan? Chair, members of the committee, thank you for the questions. There's one question about pretrial detention and the percentage of juveniles in detention that were later found to be innocent and acquitted. So we don't have the data at hand. We will go back to our statistics office and give you the latest data. In addition, for children with disabilities and they serve as witnesses in the court, what kind of assistance or support do we offer them? The court, when dealing with juveniles with or without disabilities, attach great importance to providing full support for them. For example, their parents can accompany them. Professional social workers can also stay with them. And there may be some assistance to help the victim or the juvenile to get familiar with the proceedings. So this will be a proceeding assistant to keep the child company. For example, when the child serves as the witnesses in the court, the proceeding assistant will also advise the lawyer or the judge what kind of questioning approach will be more appropriate, or psychiatrists can be invited or psychologists can be invited to accompany the child. Also, the Judges Academy offers courses for judges to learn how they can interview children with or without disabilities. Every year, our judges receive this kind of training. Thank you. Thank you. Next, the Ministry of Justice, please. I would like to provide additional information. As colleagues from the Judicial Yuan has offered very detailed explanation. Well, because we want to make sure the child's parents can come to visit them at the detention center. Therefore, we do have very stringent requirements about separating adults and juvenile detainees. We also have complaints review committees in place where impartial third parties will be invited, and they must outnumber our own staff on the committee. The National Police Administration, yes. Good morning. I would like to provide some additional information to complement what my colleagues from the other two agencies have said. I have 5 points to make. First, National Police Administration, in dealing with cases involving children and youth, we do have one dedicated agency. There are 22 cities and counties in Taiwan, so we have 22 juvenile police teams. In addition, we also have 22 police task force for women and children-related affairs. Since last year, we have also expanded the size of these different precincts. We have 159 precincts throughout Taiwan, and we have increased 200 protection officers who will provide child and juvenile victims of severe crimes. We also have juvenile crime prevention officers. We have 159 such juvenile crime prevention officers at all the precincts. In addition, we have 218 domestic violence prevention officers. So all the manpower prevention officers, protection officers, they are experts in respective fields. That means we have been providing them specialized training on a continuous basis, so they are well equipped to help juveniles and children when they suffer any crime or involved in any crime. Secondly, there's one question about pretrial detention. From the police perspective, we don't have the right to order pretrial detention, but in practice, since the arrest of the juvenile suspect, the police has 24 hours to perform investigations. Within the 24 hours, according to the Habeas Corpus Act, if the child or the juvenile files a submission based on the Habeas Corpus Act, we have to terminate and suspend the investigation and transfer everything we have at hand to the juvenile courts. In other words, the police has no power to order or to detain juveniles before trials. Thirdly, children or juveniles will inevitably stay at the police station to help with the investigation. During this period of time, we make sure that the police officers inform the child's parents or legal guardians or any impartial third party, maybe the neighborhood chief, school teachers, to come to the police station to accompany the child or the juvenile throughout the interrogation. Without such a person in presence, we will not initiate any interrogation. Secondly, the police officer has to tell the juvenile what crime he or she has committed. And we will also tell him he has the right to seek aid, legal aid. Just like the other colleague said, the legal aid may be a lawyer or lawyers dispatched by the Legal Aid Foundation. If the child or juvenile doesn't want to have a lawyer to help him, maybe a psychologist, a counselor, a teacher can also be asked to come to help him. We also tell all the police officers that when interrogating a juvenile suspect, make sure he is not treating a criminal. He is trying to help the juvenile. That's the kind of attitude he should have. And we also tell the juvenile suspect or the juvenile or the child that you have the right, according to the Habeas Corpus Act, most important of all, throughout the process, we make sure it is confidential, the privacy of the children or the juveniles are protected. What do we do? For example, we do not allow the media to take pictures. We do not allow journalists to come to interview the juvenile, and the CCTV's image must not be filmed by the journalist. And ultimately, we will have to destroy all the dossiers in relation to the juvenile or the child at the precinct. Fourthly, as I said, the juvenile or the child will inevitably stay at the police station for some time. Whether or not everything will be video and audio recorded, actually, it is only in the case involving sexual exploitation or sexual abuse, the interrogation will be video and audio recorded throughout. But there are no such requirements for victims or perpetrators of other crimes. Therefore, we will ask the victim, do you want the interrogation to be video and audio recorded? If they give their consent, we will record everything, and the recordings will then be transferred to the juvenile court. Lastly, throughout the process, when we face either the victim or the perpetrator, we do separate them. We will inform the party concerned that the perpetrator and the victim will come to the police station on different days. They will be interrogated at different times, especially for victims. We may choose a place outside the police station to conduct the investigation or the interrogation. For example, in hospitals, they do have a dedicated space for such purposes, or there may be some NGOs that can provide such space, or we can also find a space, a room in the Juvenile Guidance Commission's office. In that case, we can avoid any secondary harm to the victims. Okay, the Department of Protective Services from the Ministry of Health and Welfare. Yes, sexual abuse against juveniles and children, there are different laws in place. Sexual abuse is governed by the Sexual Autonomy Obstruction Act, and for sexual exploitation, it used to be governed by Human Trafficking Control Act. But even though there are different sources of laws, the protection for the rights and the interest of the victims, the children, and the juveniles are the same. We try to provide protection to our children so that they won't be subjected to further sexual exploitation. We also want to make sure they can recover physically and mentally. So in the case of sexual exploitation against children, in the investigation or interrogation process, social workers can keep the victim company. The social worker can also share his opinion with either the police officer or the prosecutor or the judge. And at the police station, the prosecutor's office, or the court, social workers will see to that a safe environment is provided for the child. For example, separate interrogation, separate interviews. In some cases, such interviews may take place outside the court. Moreover, when it comes to sexual harassment or sexual abuse cases, who is the subject, who is the object, we always explain clearly to the child victim as well as what may happen next in the process. The child will be fully informed of the situation. He will be aware how important his appearance in the court is. But in the end, it's the child's call whether or not he wants to appear in the court. In sexual abuse cases, we do have requirements not to make the child victim of sexual abuse repeatedly interrogated or interviewed so as to avoid further harm to the child victim. For child victims under the age of 12, maybe their memory is not so clear or they have difficulty understanding the legal language in the court, or to prevent any contamination of his testimony. In addition to recording his remarks, we also have another procedure where trained judicial interviewer will ask questions on behalf of the prosecutor or the judge to make sure that the child victim is able to understand the questions so that he can answer consistently. Thank you.
Thank you. Is there any response from NCC? Right, I think child pornography was mentioned earlier. Now, what I want to start is by saying that inappropriate behavior on the internet or off the internet are all regulated by laws. And in 2013, August, NCC and other agencies worked together to establish a mechanism, iWin. And iWin receives complaints about improper content on the internet. Now, when iWin receives such a complaint about child pornography, it retains the evidence and transfers the case to relevant agencies for further treatment. Thank you. So what support is given to students who were released from correctional schools? In order to help these students to be reintegrated back to schools, there is transitional guideline that we have to follow in order to such students. And under MOE, there is also a guideline to help drop out students. So we use these two acts, or we follow these two acts to support the children back to their schools and their lives. And before these children return to their classes or schools, they may need some extra studying hours just to catch up with the teachings in the school. And MOJ and MOHW have a coordination task force to help in this regard. If this child is between 6 to 12 and is subject to compulsory education, and this child may return to his or her original household or to the school in that area, or go to school which is near to the correctional schools. It's up to the child. And if this child is not subject to compulsory education, meaning he or she is over 12 years old, 15 years old, then again, he or she may choose which schools they want to attend. And if they are high school age students, they may submit application to this school to express his or her willingness or intention to participate in that school. And the timing of such application is not limited by the usual stipulations, because these children will be considered to be special cases, that the timing can be very flexible for them to submit the application. And it is by law that schools must not turn away these children. And if schools do turn away them, the principal or the staff in the schools will be punished accordingly. These children will be discussed at the case meetings. So the counselors at school will talk to the teachers of this child or arrange special studying program for this child, because they won't be able to catch up with the studies immediately. So the schools may arrange a special class, a transitional class for these students to catch up with the studies. In this class, teachers will provide extra instructions to help these children to catch up. And this child may also want to attend music class, art class, or other skill class. And the child is free to choose what flexible lessons he or she wants to attend. In addition, in adapting to the school life, we ask the social workers to help the children. Social workers will accompany the child for a year. The social worker will ask the child whether the child faces any difficulties being reintegrated back to school or the society. So that's a one-year program. Oh, I think we missed two questions on drug abuse and abuse prevention center and extraterritorial issues. So maybe in the afternoon we can ask the MOJ to respond. So, Mr. Chair, the floor is yours now.
Thank you very much for paying attention to two questions that were missed. We have perhaps a lot of follow-up questions, but the question is, Your Excellency, whether we need to come back in the afternoon and whether we should not conclude our business right now, because we are well over time according to the planned schedule, and unless members of the committee have different views, I would suggest that this is our last meeting, because the afternoon, to have everybody coming back for half an hour perhaps, or in order to justify, we may come up with a lot of other questions. So I think we have enough information on the issues that were raised under Cluster 8. From you, very detailed sometimes, so we are very pleased with all the information that we did receive over the last 1.5 days, starting yesterday at 9 o'clock and now closing at about 1 o'clock. The committee, and on behalf of the committee, we want to commend your commitment to this meeting, your willingness to provide all the information that you could provide on a wide range of issues. As you know, now in more than 9 hours, 10 hours of dialogue, you are also very exceptionally treated. You are a special country, but in Geneva, delegations of states parties get just 6 hours. So you have been treated very exceptionally, and we appreciate your endurance, your willingness to stay with us for those 10 hours. As you know, we will our work continues as yours, I assume, and we will set ourselves to the preparation of the concluding observations for presentation on Friday morning. And I hope to see you back on Friday morning to enjoy our beautiful recommendations that are meant to support the further implementation of the Convention on the Rights of the Child in a country that has shown already a lot of commitment to that implementation. So all of you, and particularly Your Excellency the Minister, thank you very much for your input in the work of this committee and the information that you provided, which helps us to draft hopefully well-targeted concluding observations and recommendations. So, Minister, you may, as is usual in a criminal court, the suspect has the last word.
Maybe judicial yuan or the data related to legal aid can be collected before 2 p.m. and please submit to our secretariat, and such data will be provided to the committee members. So about extracurricular prosecution, about drug use centers, maybe such answers can be provided in written forms and be submitted to the committee members so that they can start drafting the concluding observations and recommendations. Before we officially end this session, I want to thank the 5 committee members. Let's give a round of applause to the 5 committee members for staying so long with us. I think we have gone over more than half an hour in the morning session.
For submitting further information, not necessarily before 2 o'clock this afternoon. By the end of the day would be fine. Okay? Good luck with your further work. Enjoy your lunch and see you on Friday morning.
请司法院、教育部、法务部协助提供相关的英文补充资料7份纸本以及电子档1份，于今日下午5点以前交由主办单位。再次提醒，请司法院、教育部、法务部提供英文补充资料纸本7份、电子档1份，交由主办单位于今日下午以前。那再次感谢各位参与上午的会议，我们在场外为您准备了午餐的餐盒，请各位可以到场外取用，并留在现场享用。我们将在1点半进行清场。那请各位离开时注意您的随身物品，以及务必归还口译设备，不要遗留任何的物品在本会场。谢谢您的参与。